Court is now in session.
Good morning. This is the May session for the Court of Criminal Appeals in Nashville. The panel today is Judge Robert Montgomery from Sullivan County, Judge Tim Easter from Williamson County, and I am Norma McGee Ogle from Sevier County. Each side will have 20 minutes for your arguments. And if you would like rebuttal time, please let me know before you begin your arguments. Would the clerk call the case, please?
State of Tennessee versus Noel Maltese.
Good morning, Your Honors. I represent Ms. Noel Maltese today, the appellant, and I would like to reserve 5 minutes for rebuttal, please. As the court may have noted, and I wanted to point out in case it didn't, I was not the trial counsel in this case. This case was tried in Williamson County. Mr. Eric Larson did a wonderful job trying the case. It was Judge Robert E. Lee Davies who tried it in Williamson County, sitting as a special judge. My client, Ms. Maltese, was convicted of conspiracy to commit theft over $250,000 and criminal simulation. And the trial really was about Ms. Maltese's brother and co-defendant, Mr. Leighton Ward. The state's proof was basically that Mr. Ward concocted this scheme wherein he would try to pitch to people that there was an issue with their mortgage, and he would propose to be able to help them out and save the money or get them out of having to essentially pay their mortgage. So he claimed. He set up this entity called Advocacy for Consumer Rights, and he also had involvement with this fictitious court called the Federal Postal Court. He held himself out as the clerk of this court. And the victim here was the Qualls family. And long and short of it is the Qualls got suspicious, and when they confronted Ward and called the police, Mr. Ward caused to be filed documents with the Register of Deeds office in Williamson County, purporting to try to take ownership of the Qualls residence. The state's proof was that Miss Maltese mailed some flyers out for her brother and also answered some phones per a script that Mr. Ward had drafted. And it was undisputed, though, in this case that Mr. Ward was running the whole scheme. The lead detective here, Detective Eves in Williamson County, testified that he didn't even seek to interview Miss Maltese prior to asking for charges. And Detective Eves also admitted that when he was investigating online about this postal court and about this entity called Advocacy for Consumer Rights, that he didn't come across Miss Maltese's name whatsoever. It was admitted by Miss Maltese that she answered the phones. She testified, by the way, and she admitted to answering the phones. She admitted to mailing some flyers and admitted that she had filed a document with the Register of Deeds office. Her defense was that she was just following her brother's instructions. She testified, and it was undisputed that she didn't have any experience in the mortgage industry or the legal industry with respect to how documents are filed with respect to property and whatnot. Her defense was that she was just following instructions, and she didn't have any reason to know what was going on with her brother. What he was doing was illegal. And for after giving that background for oral argument today, I'd like to focus on the issue regarding the evidentiary issue regarding some questions that the state was allowed to ask of Miss Maltese when she testified regarding her brother's criminal history. There was a bench conference before this testimony came out, and so there was an objection made. And basically, over the defense's objection, the state was allowed to ask Miss Maltese about how her brother was serving a very lengthy prison sentence in Arizona, with the implication being it was for the same or similar conduct that was before the court for the trial. Now, the state's going to argue that Miss Maltese opened the door to this line of questioning by basing her defense on the fact that she was just following her brother's instructions and had no reason to believe that he was doing anything illegal. In other words, the state is arguing that Miss Maltese opened the door to the reasonableness of her reliance on what her brother was doing. The problem, however, with that argument is that there's a time frame issue here. The events that are alleged to have occurred in this case were alleged to have occurred in early 2017. It wasn't until after that Mr. Ward was convicted and went to prison. So it was, just not relevant at the time as it pertained to Mrs. Maltese's testimony that she didn't have any reason to believe that what her brother was doing was wrong and that she was following instructions and thought he was helping people. It wasn't until after the fact that Mr. Ward was convicted and went to prison in Arizona. So we argue for that reason it's not relevant. And, and Miss Maltese certainly didn't open the door to that line of questioning by testifying that she felt that she was justifiably relying on her brother back in 2017 when he was instructing her to do these things. It would have been different, we propose, if Mr. Ward had went to prison sometime before the events alleged to have occurred in this case and was released and then got into the scheme and elicited Miss Maltese's help. Under those facts, if Miss Maltese knew that Mr. Ward had previously faced consequences for that conduct, then that certainly would have been relevant to cross-examine her based upon her testimony that she was just relying on what her brother was telling her and that she didn't have reason to believe it was illegal. And it's our position, even if the court rejects that argument and finds that it was relevant and that Miss Maltese did open the door to it, it's our position that the probative value of the evidence was substantially outweighed by the danger of unfair prejudice. And that's, we contend, pretty plain because the eliciting testimony that Mr. Ward was serving prison time for conduct essentially the same as the conduct that Miss Maltese was on trial for is inherently prejudicial. I cited a couple of cases on Miss Maltese's behalf in my brief where courts had reached had used similar logic. Nothing is directly on point, but we contend it was inherently prejudicial for the jury to learn that Mr. Ward was in prison in Arizona for this conduct. And we would argue that even if the court rejects my argument that Miss Maltese didn't open the door because of the time frame issue, we submit that at the very least would reduce the probative value of the evidence relating to Mr. Ward's imprisonment. And as the court knows, in the Rule 403 balancing test, the court has to determine what the probative value is, and then whether or not the probative value is substantially outweighed by the danger of unfair prejudice. So if the probative value goes down because of the time frame issue, then it may very well, and we contend was, outweighed by the danger of unfair prejudice. And so even if relevant and proper, it should be excluded under Rule 403. And as far as the state...
I have a question, just a minute. Was she still at trial, this according to the state's brief, still taking the position that her brother was this great guy who was just trying to help people and not do anything wrong?
She testified to that, yes, ma'am. As it related to her, we would argue, state of mind at the time of the events that are in question, because she was questioned about, why was she, doing these things? The state's argument was that she should have known better. Her response was that, well, I was just following instructions of my brother, and I didn't have any reason to to think that he was engaged in anything illegal. And it wasn't until after that he was convicted and went to prison.
So she was no longer acknowledging that he was just trying to help people.
That was her testimony, that she thought, based upon how things went down, that she did think that he was trying to help people. But I think that relates to at the time of the offenses in question. And as far as the issue of harmless error, the state's argument is going to be that this was harmless error and that this is just one small part of the trial. And that's true. But here we would argue that it's undisputed that Mrs. Maltese's role in this was minuscule. The whole trial was about Mr. Ward. Mr. Ward was the one really on trial, we would contend. Again, the detective didn't even seek to interview Miss Maltese prior to filing charges in the case. He admitted that, flat out admitted, the detective did, that it was Mr. Ward who was running the scheme, so he concluded. And because of that, the state needed a way to make it stick against Miss Maltese. So we would argue, what better way to do that than to show that Mr. Ward was serving prison time in Arizona for basically the same conduct. So for that reason, we would contend that it was not a harmless error and that it did nothing but suggest to the jury that they could find guilt on an improper basis. Thank you. If there's no further questions, I'll reserve the rest of my time for rebuttal.
Mr. Krieger, just so I'm clear, Mr. Ward and the defendant's mom were also co-defendants in this case, correct? Named in the indictment.
Yes, sir. Sorry, I didn't point that out initially. That's correct.
No, that's okay. So they were all severed for trial?
Well, I believe so. I believe Mr. Ward had later entered a plea agreement after the trial in this case. I'm sorry, but I don't know what finally happened to Miss Gilly, the defendant's, my client's mother.
Okay.
Good morning, Your Honors. May it please the court, David Finley on behalf of the state. The defendant in this case made her brother's character relevant, his general character. The import of her testimony at trial was that he was and is a trustworthy person. Volume 8, 284, she believed everything that he told her was legitimate, and she still believed that. So we would submit that having opened the door to his character, his general character, at that time, at the time of that and at the time of trial, that the state was entitled to ask, well, isn't he doing 23 years in prison for the same thing? We submit that also that the jury could infer as to this timeline issue. The defendant's investigation took about a year and a half, somewhere in that neck of the woods. And I think the jury could reasonably find that if he was doing 23 years at the time of her trial, that his investigation was going on round about the time that they were engaged in this fraud with Falls family. So on those two bases, we think that the trial court properly allowed this. It was not unduly prejudicial. All of the state's evidence is prejudicial. It's not unduly prejudicial because, as the defendant notes, this case was about Mr. Ward, basically. She and the defendant put her entire lock, stock, and barrel of her defense squarely on his shoulders. So his character is at issue. Even if the court should disagree with the state's argument, excuse me, any error was harmless. And the court looks at the proof and whether this could have affected the verdict. And it could not have affected the verdict. The proof here established that the defendant had bought and sold homes legally in Tennessee. So she was well aware of the legal requirements for buying and selling homes. She herself admitted, as did her husband, I think as well, her ex-husband, no one had ever been helped by her brother. No one. Her brother made $3,000 off of people. She herself made $100 every time he made $3,000. So this is a business that helped no one but her and her brother. She acknowledged signing the warranty deed for the Qualls home, even though she had told them she would never take the home away from them. She told Mr. Qualls to get his wife under control and that she believed everything was right. The question that the defendant complains about, this question about her brother, was about 4 sentences in a 50-page cross-examination right at the very beginning. So it's a very minuscule part of the cross. The state did not belabor the issue. They just simply asked her about it and then moved on. And finally, she was acquitted on count 5, hindering secured creditors. So on all those bases, we would submit that even assuming that this was somehow improperly admitted, that the error was harmless, it did not affect the verdict. And we ask you to affirm.
Thank you, General.
Thank you.
Rebuttal? Mr. Krieger?
Yes, ma'am. Thank you. I'll start out by just noting, as the state seems to agree, that yes, the case was all about Mr. Ward, and to address the issue about regarding Judge Ogle's question and regarding some arguments made by General Finley, the applicable part of the record here where this interchange took place was Volume 8, pages 294 and 295. The two key questions here, and I think I don't want to engage in semantics, but I think it's important the way that they were phrased. And the district attorney asked of Miss Maltese about her brother, do you think he was trying to help people? Past tense, was. And also ask, and do you think what he was doing in order to try to help those people was legitimate? So the questions pertain to what had happened in the past, and she answered in terms of what she felt at the time. You know, I don't know how else you'd answer that question, because the whole trial was about conduct that occurred in 2017, and she's being asked, well, what did you think about what he was doing? You know, and again, that was before Mr. Ward was convicted and went to prison. So we'd argue that it's not relevant, again, for that reason. And to briefly address the harmless error issue again, the state pointed out that, well, Miss Maltese was acquitted of count 5, hindering a secured creditor. We would note here that that's true, but the state didn't offer any proof from any mortgage entity. The witnesses were Miss Maltese, of course, testified for the defense, but for the state, it was Mr. Qualls, the detective, and Mr. Richard Maltese, who was the ex-husband of my client. I don't believe there were any other witnesses other than that. So it's obvious why she was acquitted. It's our position of that charge. Thank you.
Thank you, gentlemen. That concludes the argument for this case, and we are ready to recess.
This honorable court is in recess until 1 p.m.